Next, we will study the signing of international trade contracts and stocking. First, let's look at the time of contract formation. According to the provisions of the United Nations Convention on Contracts for the International Sale of Goods, CISG, the time of contract formation is exactly when acceptance takes effect. The time of acceptance becoming effective is determined by the notification reaching the offerer or by the acceptance action taken in accordance with tradeways and offer requirements. The time of contract formation is when the acceptance notification is received or when the acceptance action is taken. Therefore, in actual businesses, the contract should specify the date accordingly. The contract law of China stipulates that if the parties have concluded the contract in writing, the contract enters into force when it is signed or sealed by both parties. The forms of contracts include written form, oral form, and other forms. There are 6 forms of written contracts. The first one is a contract, which is a comprehensive in content and clearly specifies the rights and obligations of both parties. It includes key provisions and general clauses. It can be further classified into sales contracts and purchase contracts. The second is confirmation. It is a simplified version of a sales contract. Generally, it only includes the main terms of the transaction and some general conditions. A confirmation can be further classified into sales confirmation and purchase confirmation. The third is an agreement or letter of agreement. It provides clear, specific, and affirmative provisions for the rights and obligations of both buyers and sellers, and has the same binding force as a contract. However, preliminary agreements or principal agreements are excluded to this extent. The fourth is a memorandum. If the buying and selling parties agree on the transaction conditions which are clearly and specifically stipulated in the memorandum, and both parties put their signature to it, then the memorandum has the nature of a contract, meaning that it is binding. However, memorandums of understanding or memorandums of agreement are exceptions to this rule. The fifth is the letter of intent. It is a manifestation of willingness made by the parties involved in order to reach a certain agreement. It is not legally binding on either party. The sixth is an order and intent. After negotiation, the order and intent sent to foreign clients are considered as the sales contract or purchase confirmation. Having learned the written forms of the above 6 contracts, let's now study the basic content of contracts. Contracts consist of 3 fundamental elements. The head. It serves as the introduction to the contract, including the contract name, the number, the date, and place of contracting, the names and addresses of the contracting parties, and the legal relationship between both parties. The body is the core of the contract. It encompasses all transactional terms such as the commodity name, quality, quantity, packaging, as well as shipping, price, insurance, payment, inspection, claims, attribution, force majeure, and so on. The tail. This refers to the concluding part of the contract, including the number of copies of the contract, the language used for creating the contract, and its effectiveness, the basis for creating the contract, signatures of the contracting parties, as well as their detailed contact information, telegrams, telex, fax, etc. Next, we will learn about the relevant content of stock preparation in international trade. First, the signing of domestic purchase and sales contracts. Large enterprises with export operation rights usually have their own production workshops. When exporting goods, these enterprises usually issue a complete equipment stock preparation notice to the production and processing departments, as well as the warehousing departments, through the export department. Foreign trade enterprises that do not participate in production and processing businesses mainly implement stock preparation by signing domestic purchase and sales contracts with domestic manufacturers, namely factories. Second, goods acceptance and storage. Foreign trade enterprises, after signing domestic purchase and sales contracts with domestic manufacturers, need to regularly visit the factories to keep pace with the production progress. They inspect the product quality, identify and resolve issues promptly. Upon successful acceptance of the goods, they can then proceed to fill out the goods purchase entry form and complete the procedures for goods storage. Third, packaging marking. In order to prevent theft of the goods, it is necessary to label the outer packaging of the goods or identify the brand of the goods. Marking refers to the painting or imprinting shipping mark on the outer packaging, so as to facilitate the carrier and the consignee to identify the goods. During the process of marking, attention should be paid to the following issues. The painting of shipping mark should comply with the regulations of the relevant importing countries. The shipping mark on the packaging should match with the description on all export documents. The shipping mark should be concise and also provide sufficient transportation information. The size of the shipping mark should be moderate, allowing relevant personnel to catch them clearly from a certain distance. Shipping mark should be painted on at least 4 sides of the packaging box to prevent loss of goods. Apart from painting shipping mark on the outer packaging, the same shipping marks should also be marked on all freight documents as much as possible. These are common shipping marks used for the transportation of various types of goods. Now, let's delve into the exploration and improvement. A few minutes is for you to analyze the situation and consider how it should be handled. Feel free to discuss and exchange ideas after class. Thank you for listening.